But in their papers, they argue that I have the burden of proof. I cannot hold the burden of proof when the person opens a case of escape from lawful custody, because the reason why we are having a challenge of this matter is because the challenge is based on the warrant of sentence. That warrant of sentence, Your Honor, is purely stipulated clearly that a person that is sentenced in correctional services must have a warrant. And when the person escapes, he doesn't escape from a building. He escapes from the warrant. That warrant is the challenge. Now, we don't know. They say that the warrant is valid. But only a court can make that's determination. Now, they're making determinations and classifying me. And if they put me as an accused person in detention, they do not lose anything. There's no harm that will be caused to the respondents. I would still be in their custody. I'll still go to court. I'll still defend myself. But it will be in a fair manner that is within constitutional rights of everyone. And that is all I am asking of this court, to take consideration that the presumption of innocence is a fundamental right that all are bound to go unto. But the respondents argue wrongfully that the burden of proof and the presumption of innocence do not apply to me because of the fact that I'm convicted. So basically what they're arguing is that because I'm convicted of rape and murder, which is a challenge in a different court, they feel that I have no right, that I cannot defend myself in this manner, that the warrants are an absolute. There is no warrant in the world that is an absolute, Your Honor. A warrant may be amended through the Correctional Service Act, through the executive power, through an application through the court. So there are many ways that one can actually not serve a full life sentence or 10 years of a sentence. There are many executive decisions that could be made. And if those decisions are made, you cannot hold me to ransom on the basis that you accuse me of violating. You must give me an opportunity to ventilate my case. And in this application, the center and the core of my argument is that I'm not able to be treated as a normal inmate, being given normal treatment. I am treated highly. All these people that I come in here, in security, it's based on escape. I have no violence. In the 15 years they claim that I have been in prison, there's no case against me. There's nothing against me. In the time that I was outside, I violated no one. Your Honor, I will bring it to this court attention that escape, it is a charge under the Correctional Service Act. And the Correctional Service Act charges me with escape, then makes a decision, and after making a decision, take me to court for the same matter. Now, technically, that means that the legislation itself, when you're dealing with what correctional services conduct is, they have supreme power over the Constitution and over my rights, because they can act and do as they please. Currently, I'm in solitary confinement. They refuse to take me out because they say that I should finish my trial in Bloemfontein. But that trial can continue for 10 years. And at the time I reach the trial, I might not be fit to stand trial. I will also say that the respondents are a direct interest to the trial in Bloemfontein. They have to prove that I'm guilty. And I am in their custody. That is sort of like taking a person that has violated someone and say that stay with the person that you violated. They're not going to treat you fair. They're not going to treat you with dignity. I am treated for this. I am the longest serving person after Robert Sibukwe in solitary confinement. I live in CMAX, not for everyone. I live solitary by myself. I see no human being for the past 3 years. And that is purely based on an accusation. There's no facts. I have not defended myself. And the respondents stand on the ground that I was sentenced. I do not challenge that I was sentenced. But I challenge the validness of that warrant. And I challenge it in the Bloemfontein court, not in this court. This court is to challenge, do I not have presumption of innocence? And do I not qualify to be innocent until proven guilty? The responsibility to prove beyond reasonable doubt is with the respondent and the state that I am guilty. And that has not been proven, but I have been treated as such. There are even judges that have made accusations to say that I am guilty of escape in transfer applications. Now you question yourself that would there be a fair trial in the circumstances? And do we say that because I'm convicted of rape and murder, I don't deserve a fair trial? I don't deserve a fair proceeding as required and guaranteed by the Constitution? Because that is the actual challenge here. The challenge is not that the respondents can put me in prison. I have no challenge in being in prison. But the challenge I have, I just want an opportunity to state my facts. And in that process, be able to argue. Because my medical file has been attached here in this court by the state. But they only chose, and I don't have access. They do not want to give me an opportunity to make copies of that medical file and be able to give it to this court. But the court would see that since I have arrived from the 13th till today, I've lost 36 Ks in solitary confinement. I speak to no one. I only see people when I'm here. And it's overwhelming. But you have to chin up. Because at the end of the day, if you don't